Welcome and thank you for attending. Questions may be asked the questions pane in the webinar control panel. Today's presentation will be recorded. If you have any objection, you may disconnect at this time. I will now turn the presentation over to your presenter. You may begin.
Good afternoon, SHRM Long Island, Lunch and Learn participants. This is Henry Shapiro from Jackson Lewis. You seem to be getting a lot of me lately and some of Chris Valentino, but I thank everybody for logging in, signing on today. So it's Friday, it's 12 o'clock, it's somewhat hazy out here over in Nassau County or Suffolk, wherever we are, but we're gonna today talk about where we're not Nassau or Suffolk. We're gonna talk about New York City. For those of you who have operations in New York City, for those of you who have employees that touch New York City, end up working in New York City, maybe you think to yourself, oh, they only do a couple of hours in New York City every week. They're not really a city employee. Well, what we're going to ask you today is to kind of reevaluate and see maybe there's certain things you need to do for these employees that you didn't have to do before. So I tried to go with a throwback title, so I hope you appreciate the creativity of Summer in the City. So we're doing an update on New York City laws. So a lot of you get frustrated with New York City. You're not alone. This office does as well. We understand and feel your pain. But New York City, as we all know, is for as progressive and as protective of employee rights as New York State is. New York City takes it even further. So New York City continues to make amendments, updates, and add new laws that pertain to the workplace. The New York City Fair Workweek law, which previously really only dealt with the retail and fast food industry, so I'm sure a lot of people dialed into this webinar didn't pay too much attention to, now has been amended to include temporary schedule changes, which the majority of this presentation is about, because you're going to see that it may well apply to a handful of your employees. Then we have the New York City Earned Sick Time Act, which some of you might know as the Paid Sick Leave Act or the Paid Sick Law, where it gives those 40 hours or 5 days of paid sick time for New York City employees. That is also going, and New York City employers are covered under that law. It's also going to have a slide or two, I think, in this presentation on recent changes where they've added safe time. It's not a remarkable change. It's kind of the way the national trend is going for these paid sick leave laws to cover safe time, and it's not, too shocking. And then you'll notice that we are continuing to monitor, which I think is something of interest to everybody on this call, the sexual harassment changes and updates to both New York City and New York State, as I'm sure you have heard us talk about to the point you don't want to hear it anymore, except for let's just pretend this part where you will listen. The sexual harassment, Me Too movement has generated new legislation, new laws in New York State, which obviously will cover everyone from Albany down here to Buffalo and so on, and in New York City, which will obviously cover the 5 boroughs. There is the movement for interactive training, annual training, coverage applying to more employers than other parts of the human rights law, so we're going to get into that a little bit too. So the Fair Workweek law, so this is what I was alluding to earlier. It deals primarily with the retail and fast food industry. However, it's been recently amended such that it occurred, I want to say, in January of 2018, and then they always have about a 180 to 210-day period where there's a chance for everybody on this webinar to get brought up to speed and kind of get their policies in line and get used to the new changes. So just about a week or so ago, effective the 18th of July, New York City employers must grant temporary work schedule changes for employees. So there's caveats to all of this. It's ultimately going to be 2 in a calendar year, 2 work changes, and it could be 1 if it's a 2 business day period. But we're going to get into the inner workings of this over the next 15 or so minutes. So this is an amendment to the New York City Fair Workweek law. This temporary work schedule part, applies to all New York City employers, not just retail and fast food, and it's going to cover a lot of employees for possibly what you might not refer to yourself as a New York City employer, but it might apply to your employees, which we were talking about a few moments ago. So covered employees include anyone who works at least 80 hours per calendar year in New York City. So that could be you send them in there for an 8-hour meeting once a month, and they do it every month. Do the math, that's 80 hours in 10 months. So if they're doing it for all 12 months, then you got somebody that's working more than 80 hours, and they're doing it maybe out of your city location or at a coffee shop in the city, and they're holding meetings there, or a hotel. And they have been employed with you for at least 120 days. So that's something that New York City commonly refers to as that first 4-month threshold. Nobody's eligible, but ultimately they exceed the first 4 months, and then they're in. With limited exceptions, an employer must grant an employee's request for a temporary change to the employee's work schedule because of a personal event. So that begs the question, what is a personal event? That is coming up because the first things that you should know is, what is a temporary change? What are we talking about here? So temporary change could include working remotely, swapping shifts, adjusting shifts. Essentially what you're doing, or what your employee is requesting, is that their regular schedule that they work, maybe they work 3 to 11 every Wednesday, and they can't work 3 to 11 this Wednesday, or one Wednesday coming up they need to work 12 to 8. That would be a schedule change, somewhat self-explanatory. Employers must grant these temporary changes, and keyword is temporary, must grant these temporary changes to the usual work schedule of the employees, which could be changes to hours, times, locations, on 2 occasions each calendar year for personal events. So I mentioned it before, you get 2 shots at this as an employee, and then it reboots the following calendar year. So employers have the option also of granting unpaid leave in lieu of the temporary change requested by the employee. So if you can't accommodate them working at a different schedule, and you just want to give them the day off, and you don't take any retaliation or retribution, nothing against the employee for doing this, that's permissible under the law and under the interpretive guidance that's currently available. So as I said earlier, these requests, it could be 2 separate business days or one occasion of 2 days. So it's, again, pretty straightforward. A business day is a 24-hour period. Also straightforward. Here is what you should want to know. What is a personal event? So this is what they can request, they being employees, what they could request temporary work schedule changes for. The issue is you're not going to have much in the way of being able to get proof of this personal event. So you're going to have to kind of rely on your employee to not lie to you. Good luck. But what is a personal event? Personal event occurs when an employee needs to, you can read the bullet points, but it's if they're caring for their child, for whom they care, they provide usual direct care. So that's mom, dad, I guess depending on the relationship. Care for the individual. So you'll see a lot of this for those of you covered by the FMLA, for those of you loving paid family leave. You'll see this care recipient term come up pretty often. So a care recipient with a disability for whom the employee provides direct and ongoing care, who is a family member. I'm going to get into the lovely definition of family member, I think, in a slide or two, who resides in the caregiver's household. So keep in mind, there's nothing right now that says this is for you to take a day or 2 off if you're working in the city to fly to California to care for your, sick parent or sick child. If you could do the travel in 24 hours, maybe you could swing it, but it does say caregiver's household within the law. Attend the legal proceeding for public benefits of the employee or the employee's child, and you can use the schedule changes for any reason under the sick and safe leave law, which we'll get into a little bit further on. Who is a family member? So it is not a short list. If you have ever met somebody, my joke would be that they're probably your family member, according to New York City. Your neighbor, your dog, your cat, your rabbit, your third cousin once removed. You could get, family member could include any individual whose close association with the employee is the equivalent of family. So have fun with that. That's going to be a fun one to interpret. If there's ever any future case law or guidance on this, I look forward to being able to share that with all of you so you can see what a close association that is the equivalent of family becomes. You're soon going to have very large families from your employees. More standard, we'll get the child, and it covers all forms of the child, the biological, the adopted, the foster, sorry. the child of an employee standing in loco parentis, which will recognize from family medical leave and paid family leave. Both laws have the in loco parentis coverage, where somebody basically acting as a parent or acting they are acting as the parent of the child, even though they might not be the biological or the adopted child of that individual. You can have the grandchild, spouse, so current or former. Again, this is a very, very broad stroke coverage. So your ex-husband, ex-wife could be covered as a family member, domestic partner, parent, grandparent, child or parent of the employee's spouse of domestic partner. So that's, I guess, if there's a step relationship is what you'd be thinking of. Sibling, any other individual related by blood to the employee. So again, very, very broad coverage. This is not intended to be a narrow interpretation. So, more on temporary schedule changes. An employee is not required to submit documentation to the employer with their request or provide proof of the personal events. This is what I said earlier. You don't have to, you're not allowed to demand as an employer proof. So the employee can tell you it's for this personal event reason. It'd be nice if they gave you something or clued you in as to what the personal event is, but to say they are required to do something of the sort is inaccurate. So just be cautious when, don't think that you're in a position as an employer or in an HR function to deny an employee's request merely because they didn't give you any paperwork or they didn't, they're not giving you enough information. If they give you a little bit to suggest the personal event, then give them the schedule change that they request, unless they've exceeded the 2 already in the year. Employers cannot require employees to make temporary schedule change requests within a specified time prior to the need for the change. So what you can't do is tell your employee, if you want to take off on the 1st of the month, I need to know by the 20th of the preceding month. You don't have that right. These are things that can, according to the way that the guidance reads, could happen after the fact. They could call you and then they could they could say, I'm changing my schedule today. And if that's as soon as practicable, then they might have to give you some written information after, but that's the best you're going to get. And there's not much you can do because there's a clear anti-retaliation provision in this law and in this series of amendments that somewhat tie an employer's hands. Employees must make the request as soon as practicable, and employers must respond, quote, immediately. The reason for the quotes, it's not clear, but, with most New York City laws, to the extent you can drop everything you're doing for your employees, that's usually what they expect. It's not, not too much to ask, of course, but to the extent you can, especially depending on the time sensitivity of the request, do it as soon or respond as soon as you can. When an employee submits a written request following a temporary schedule change, the employer must provide a written response. So this is worrying about written responses and written requests. You have 14 days to respond as an employer. So it's something you want to set up maybe in your system calendar at 14 days after you get the request, you have to respond in writing. What should you be looking for the employee's request? And again, a lot of this is in a perfect world because your hands, again, as we said, are tied as to what you can actually get. The employee's request should include the date of the schedule change, that the change is due to a personal event, and what are they looking for? Anybody could say they want a temporary schedule change, but what? Do they want different hours? Do they want a certain day off? Do they want to switch a schedule? What are they looking to do? And again, it's a 24-hour period, so it's not your employee who's 40 hours a week, full-time, maybe working 9 to 5, who then tells you, I need to switch each shift this week, 1 to 7 to 3, 1 to 8 to 4, 1 to 2 to 10. Doesn't work that way. If employees request a schedule change orally, so they tell you maybe over the phone or face-to-face, they then must submit a written request within 2 business days after they return to work. So if they call you and say, I'm going out of work, I need to change my schedule, I'm working I'm going to work 12 to 8 today, and Jim is going to pick up my 3 to 11 shift. That's fine, under the way the law is written now, but they have to still give you something in writing. And the reason why these writings are required is because there's, of course, record-keeping requirements for employers that we're going to get into in probably a slide or two. The written request should include the date of the change, and the change was due to a personal event, just as we said above. Record keeping requirements. It's nice when things work out. So, employers must retain temporary schedule change requests and responses. This one is pretty straightforward. There's nothing preventing you from keeping these things electronically. You don't need to keep the little scribbled piece of paper. You can scan it and you can save it. You can have an you can set up an electronic system if you want, maybe if your employees have email access, where you concern yourself with these schedule change requests. The one thing I will just say is be careful always if you're dealing with non-exempt employees using email. Always keep an eye on people answering emails after work hours, because we always want to be worried about overtime and compensation and minimum wage and things of that sort. So as we said, they can be electronic records. You got to keep them for 3 years. We over here at Jackson Lewis typically like to give an extra year just for safety. So don't be afraid to keep them for 4 years. Store them in a cloud, do what you want, put them in a box, just keep them, because if you ever get called to task on you're not following the law, you need to be able to produce these documents. As we said, there's an anti-retaliation provision, which is nothing out of the ordinary for New York City or New York State, and employers cannot request or require that employees waive their rights under the law. So you can't work out a side deal with your employee to say, just work your schedule, and in exchange, I'll give you an extra vacation day. Can't do it. So we leave the wonderful world of temporary schedule changes that will probably make your lives for your people in New York City even more difficult than they already are. We transition to the New York City Earned Safe and Sick Time Act, and despite, I think there's 1 or 2 slides on this, despite those slides, what you really need to know here is New York City Sick Time, or the Paid Sick Leave Act, has now added safe time, which is going to largely cover what you would think of, domestic violence and criminal issues, that employees can use their paid sick time for these safe time provisions, or safe time reasons. So what you should know, if you haven't already, and we talk about this, also way too often whenever we get a chance to speak to the SHRM audience, as of June 4th, 2018, there must have been an updated notice of rights presented to your employees. If you haven't done that, reach out to council, do it, get it up, get it posted, get it distributed to your employees, and they do want some kind of, they being New York City, does want some kind of acknowledgement. So, there's conservative approaches, there's slightly riskier approaches that you can, talk about with council, but it is absolutely something that you need to do. You need to get the updated notice of rights, which is the same as the one that you gave out for sick time probably a few years ago, but now it includes safe time. You must also update your handbook policies to include safe and sick time. Sick you probably already had if you're in the city. Safe you're going to add. Everything else for the Sick Time Act under the New York City Paid Sick Leave remains the same. This I don't expect anybody to read. I don't expect anybody to memorize, but just familiarize yourself with it. This is kind of what I was alluding to. Reasons for safe time. You'll see, domestic violence, anything having to do with sexual abuse, stalking, sexual offenses, human trafficking. It's a lot of, the scarier things that we wish wouldn't happen in this world, but unfortunately they do. It will now give your employees the ability to use their paid sick leave accrual to miss work or get out of jail free card, so to speak, for these covered reasons. Lastly, we'll wrap up in our final minute with the New York City sexual harassment update. The update is probably not much to update you on from what you don't already know. You probably have a good understanding, because we know this is going to impact everybody. There's going to be a New York State requirement. There's going to be a New York City requirement. For the city requirement, it is not going to kick in until April 1 of 2019, so you have some time, but I promise you that we can all agree on this call that April 1 of 2019 will be here before we know it. There's a requirement for mandatory annual sexual harassment training. What we are still waiting for, you'll notice the bottom bullet point, we're waiting. There's supposed to be training modules and models of what New York City expects, what the Commission on Human Rights expects from this training. We're expecting to get the same from New York State regarding what is expected for training. The New York State requirement begins October 9th, 2018, so don't miss that date, because that one's even closer. There's likely going to be policy changes needed to your sexual harassment policy. We are still waiting for more from New York State and New York City. There's definitely going to be an annual training requirement based on the way the law is written right now. There's this whole interactive debate. It appears that it's not going to need to be live or in person, but annual training will be required. There's going to be a deadline to do it from the time of hire for new employees, and then you're going to have to do it annually for all employees. So with that lovely recap of New York City, for any of you heading to New York City tonight, have a nice night and keep those laws in mind. And for anybody else, have a wonderful weekend and enjoy the rest of your summer. Thanks for joining.